Welcome to Law and Society and to part two of the extended summary of Jack Smith's immunity brief in the DC conspiracy case. So, in the last section of it, I went through the facts of the case in section one of Jack Smith's uh, uh, brief, opening brief in the immunity case. So, if you're new to my channel, please like and subscribe. And let's get started with the legal and then the analysis. The legal framework is quite a short part, so I'm going to read all of it because I think it's important for people to understand how the government has uh, articulated or framed how it understands Trump versus the United States. I want you to understand that there definitely does not mean that this is going to end up being Judge Chutkan's ruling, or that if it is appealed to the Supreme Court upon Judge Chutkan's ruling on this evidentiary matter, I don't think that it's going to be exactly the same. So it's important to understand what the government's standpoint is, and so that's why I'm going to be reading this. Legal framework. In Trump, the Supreme Court held that former presidents are immune from prosecution for core official acts, enjoy at least a rebuttable presumption of immunity for other official acts, and have no immunity for unofficial acts, and remanded to this court for further proceedings consistent with its holding. This section sets forth the applicable legal principles, and then Section 3 applies them to the categories of conduct that the superseding indictment alleges that the government intends to prove at trial in order to demonstrate that none of the defendant's conduct is immunized. In Trump, the Supreme Court announced the principles that govern a former president's claim of constitutional immunity from federal criminal prosecution. The Supreme Court divided presidential acts into three categories. One, core presidential conduct that Congress has no power to regulate and for which a former president has absolute immunity. Number two, the official presidential acts for which the president has at least presumptive immunity. And three, unofficial acts for which the president has no immunity. With respect to the first category of core official conduct, when the president's authority to act is conclusive and preclusive, Congress may not regulate his actions, and the president has absolute immunity from criminal prosecution. Applying these principles to the original indictment, the Supreme Court concluded that the defendant is absolutely immune from prosecution for the alleged conduct involving his discussions with the Justice Department officials and his threatened removal of the acting Attorney General. The superseding indictment omits those allegations, and the Supreme Court did not find that any other conduct alleged in the original indictment implicated conclusive and preclusive presidential authority. The threshold question here then is whether defendant can carry his burden to establish that his acts were official and thus subject to presumptive immunity. Official conduct includes acts within the outer perimeter of the president's official responsibilities, covering actions so long as they are not manifestly or palpably beyond his authority. But consistent with the DC Circuit's opinion, the Supreme Court suggested that a president who speaks as a candidate for office or party leader, as the defendant did here, does not act in his official presidential capacity. This is from a case called Blasingame, and the Supreme Court adopted this understanding. As the DC Circuit explained, the president acting as a candidate for re-election is, to that extent, not carrying out an official responsibility. Yet he does so in an unofficial. So let me read you what the excerpt from Blasingame is as well. When a sitting president running for re-election speaks in a campaign ad or in accepting his political party's nomination at a party convention, he typically speaks on matters of public concern. Yet, he does so in an unofficial private capacity as office seeker, not an official capacity as office holder. And the action taken in an unofficial capacity cannot qualify as official act immunity. To assess whether a presidential action constitutes official act, court must apply an objective analysis that focuses on the content, form, and context of the conduct in question. A president's motives for undertaking the conduct and the fact that the conduct is alleged to have violated a generally applicable law is not relevant considerations. If a president's actions constitute non core official presidential conduct, he is at least presumptively immune from criminal prosecution for that conduct. The government can overcome the presumptive immunity by demonstrating that applying a criminal prohibition to the act would pose no dangers of intrusion on the authority and functions of the executive branch. Just as the inquiry into whether conduct is official or unofficial is necessarily fact bound, with the necessary analysis being fact specific, so too should the inquiry into whether any presumption of immunity is rebutted under the circumstances. The analysis should first identify the specific alleged act at issue and then determine whether criminal liability for the act intrudes on a relevant executive authority or function, taking care not to conceive of the inquiry at too high a level of generality, meaning it has to be specific conduct, looking at each of the specific conducts. And Jack Smith does that in Section 3. Such an approach recognizes that executive authority has limits, boundaries imposed by constitutional text, the separation powers, and precedent, and that application of criminal law to the president's official conduct does not per se intrude impermissibly on executive branch authority and functions. These principles for assessing whether the conduct alleged in the superseding indictment is immune apply equally to evidence. The government may not introduce evidence of immunized official conduct against a former president at trial, even to prove that the former president committed a crime predicated on unofficial conduct. So then that is the legal part of it. That is how Jack Smith and DOJ have interpreted Trump v. United States and other precedent that the Supreme Court has adopted in how it deals with immunity, and in this specific case, presidential immunity. This starts out with none of the allegations or evidence is protected by presidential immunity. The first section addresses the defendant's interaction with Pence, because in Trump v. United States, the Supreme Court held that when the defendant conversed with Pence about their official responsibilities, the conduct was official. Accordingly, the government explains below why any presumptive immunity as to the defendant's official conduct regarding Pence is rebutted. Excuse me. So then talks about the interactions with Vice President Pence. And because the executive branch has no role in certification proceedings, and indeed the president was purposely excluded for it by design, prosecuting the defendant for his corrupt efforts regarding Pence posed no danger to the executive branch's authority or functioning. The Supreme Court held that discussions between defendant and Pence concerning Pence's role at the certification proceeding qualify as official conduct, and therefore are subject to rebuttable presumption of immunity because they involve the president and the vice president discussing their official responsibilities. Those discussions qualify as official because presiding over the January 6th certification proceeding, at which members of Congress count the electoral votes, is a constitutional and statutory duty of the vice president, according to Article 1, Section 3, Clause 4 of the Constitution. The discussion at issue did not pertain to Pence's role as president of the Senate writ large. However, instead focused only on his discrete duties in presiding over the certification proceeding, a process in which the executive, by design, plays no direct role. The person having the greatest number of votes for president shall be president if such number be a majority of the whole number of electors appointed. Only if the state appointed electors failed to make a choice, that is, no candidate has such majority, does the choice fall to the House of Representatives, who, voting by state delegation, choose immediately by ballot from presidential candidates receiving most electoral votes. So it's talking about the electoral vote process. Some of those precautions are reflected in the design of the Electoral College itself. Wary of cabal, intrigue, and corruption, the framers specifically excluded from service as electors all those who would, from situation, might be suspected too great devotion to the president in office. So it's going to the historical references in the Federalist Papers to point out how, in the past, our founding fathers and framers have approached this immunity issue. The defendant's charged conduct directly contravenes these foundational principles. He sought to encroach on powers specifically assigned by the Constitution to other branches, to advance his own self-interest and perpetuate himself in power, contrary to the will of the people. The government is aware of no contrary evidence, including any precedent other than the defendant seeking to influence his vice president in the discharge of his duties as president of the Senate in presiding over the joint session. Moreover, Congress has now made explicit, echoing and reaffirming constitutional tradition and practice, that with limited exceptions of no relevance in this case, the role of the President of the Senate while presiding over the joint session shall be limited to performing solely ministerial duties, meaning has no discretion on how to do those duties, has to follow them exactly as the letter of the Constitution states and the letter of the law states. He shall have no power to solely determine, accept, reject, or otherwise adjudicate or resolve disputes over the proper certificate of ascertainment of appointment of electors, the validity of electors, or the vote of electors. Over the vice president's, because the vice president's role is and always has been ministerial rather than substantive or discretionary, it is difficult to imagine an occasion in which a president would have any valid reason to try to influence it. The president would likewise still be free to advise. So he's talking about the president would still be free to direct the vice president in all of the other duties to discharge in the executive branch, such as presiding over cabinet meeting, diplomacy and negotiations, appointment, performing presidential duties that has been delegated to the vice president. The president would otherwise still be free to advise the vice president on how to advance the president's agenda in Congress by casting the tie-breaking votes on legislation or nominations. None of these legitimate executive branch functions would be chilled or affected at all. And then Jack Smith goes into applying the law to the cases. The defendant's decision to include private actors in the conversations with Pence about his role at the certification makes even more clear that there is no danger to the executive branch's functions and authority because Eastman's conversations had no bearing on any executive branch prerogative. Instead, all of this conduct objectively benefited the defendant in his private capacity as a candidate. The court should therefore find the presumption of immunity to be rebutted. And because the presumption is rebutted, any participant in the meeting or phone call, including Pence or Person 58 and Person 8, can testify about it at trial. Defendant's interactions with Pence as running mate were unofficial. So his conversations with the vice president about the election matters were unofficial. Person 58's one-on-one interactions with Eastman were also unofficial because they were talking about the election, and they're talking about a personal email exchange, and these interactions were outside the defendant's presence, and the latter was a series of emails. These conversations were not official within the meaning of Trump, since the defendant was not involved and did not otherwise direct those actions. And because of the other information that makes describing John Eastman an inherently private role. The defendant's interactions in his capacity as a candidate with the officials in the targeted states. So now, from the Mike Pence's analysis, where Mike Pence was not behaving in a manner that was in any way part of the executive branch's functions, and neither would the executive branch's functions be in any way impeded if Donald Trump were to be held liable for the crimes alleged in the superseding indictment. At trial, the government will introduce evidence that the defendant, in his capacity as a candidate, contacted state officials to use false claims of election fraud to induce their assistance with the charged conspiracies at the point in the electoral process in which states ascertain electors. Most importantly, as with the defendant's plan regarding the fraudulent elector slates, as president, he had no official role in the process by which states appointed and ascertained their presidential electors. The content, form, and context of the defendant's interactions with these state officials firmly established that his conduct was unofficial. When Person 16 failed, hold on one second, on November 30th, the day Person 16 signed the certificate of ascertainment declaring Biden's electors as legitimate ones for Arizona, the defendant, joined by Pence, again called P16, I'm thinking this is Rusty Bowers, again raised fraud claims and again failed to substantiate them. When Person 16 failed to do as defendant demanded after the call, the defendant attacked Person 16 publicly on Twitter. Each of these communications with Person 16 was unofficial. The defendant engaged in them all in his capacity as candidate in an attempt to elicit Rusty Bowers' support in reinstalling him as president. Then going into the Michigan legislatures. Defendant originally initiated the meeting through RNC chairwoman, Person 39, Ronna McDaniel, a private and partisan actor, and then followed up himself with other people, both fellow Republicans and strong political supporters of the defendant. But besides those people who separate from his chief of staff duties, assisted the defendant in campaign-related logistics. So that's talking about Mark Meadows. But besides Person 21, Mark Meadows, who separate from his chief of staff duties, assisted the defendant in campaign-related logistics. No other executive branch staff joined the meeting. In fact, according to Person 9, he and White House counsel wanted no part of it. So Person 21 is Mark Meadows, and Mark Meadows' involvement comes up, but he is not there in his capacity of chief of staff. He's not performing any duties that is prescribed in the Constitution as being delegated or being given to the subordinate officer that Donald Trump was doing. Donald Trump was behaving as a candidate, and here the chief of staff was working in his capacity in campaign-related logistics. When defendant responded to legislature's public statement in a tweet, the private nature of that message sent as a candidate seeking to overturn the results of his own election, we will show massive and unprecedented fraud, further demonstrate the private nature of the meeting it concerned. In addition, it was one of 6 retweets and replies the defendant sent over an approximately 13-minute period, all of which were focused on allegations of election fraud in his own race. Notably, the defendant did not conduct similar meetings in this period with legislatures in states where he had won or even where he had lost by large margins, nor did he seek a meeting with Michigan officials, the governor and secretary of state, who could have provided him with information about the integrity of the election. Why? Because they were Democratic. So goes back to calls with Person 18. The defendant's call with Person 18 on November 20th, 2020 was unofficial. Along with his private attorney, the defendant made a call in his capacity as a candidate and pressured Person 18 on electoral matters over which neither defendant nor even Person 18 had any official role. The context of the call makes its unofficial nature clear. The defendant placed the call to Person 18 along with Rudy Giuliani in his lead campaign attorney, and no White House officials participated in the call. In fact, Rudy Giuliani did most of the talking. The defendant and Giuliani were singularly focused on fraud claims that affected only defendant and did not raise any other races in Arizona. Person 18, like others who publicly opposed defendant's efforts, were harassed and threatened. The defendant's call on December 8th to Person 26, the Georgia Attorney General, who was also private. The defendant's interest in a case, Texas versus Pennsylvania, was private and personal. The lawsuit dealt only with the election of offices of president and vice president, not the myriad other races on the same ballots. Indeed, the day after his call with Person 26, the defendant, in his personal capacity and with the assistance of Eastman as his private attorney, intervened in the suit, and in doing so, affirmatively communicated to the Supreme Court and the public that he was acting and speaking in that matter in his personal capacity as a candidate for re-election. So Donald's own actions in a legal setting shows that he was operating in his capacity as a candidate. The defendant's January 2 call to Person 33 was unofficial and not subject to immunity. In content, form, and context, its content, form, and context makes clear the defendant undertook it as candidate and plaintiff in a private lawsuit in which Person 33 was a defendant, all of whom were affiliated with the campaign's litigation efforts, which defendant brought in his capacity as a candidate for President of the United States. Indeed, a federal court has concluded that person 33, that person 33's call was a campaign call rather than official business. When person 21 sought removal to federal court of his criminal case in Fulton County, Georgia, Mark Meadows tried, a court in the Northern District of Georgia issued an order declining to assume jurisdiction because Meadows had failed to meet his burden of showing that his role in the call was official rather than unofficial. Although the Supreme Court did not resolve the issue in Trump, it described the basis for concluding that using defendants' conduct of lying to and presuming state officials to pressuring state officials to change the legitimate vote in a criminal prosecution would not intrude on executive branch functions or authority. Indeed, the Constitution commits to states the power to appoint presidential electors in manners as the legislature thereof may direct. By contrast, the federal government's role in appointing electors is limited. Congress may prescribe when the state-appointed electors shall meet, and it counts and certifies their votes. The president, meanwhile, plays no direct role in the process, nor does he have authority to control the state officials who do. And the framers, wary of cabal, intrigue, and corruption, specifically excluded from service as electors all those who, from situation, might be suspected of too great devotion to the president in office. We've read that before in I believe it was section 1. But that is the ruling saying that president has no role in the election process. Under the Constitution, the executive branch has no constitutionally assigned role in the state electoral process. Okay, so then we go on to more. Defendant and Eastman's call to person 39 on December 6th was private. The defendant placed the call along with Eastman, a private attorney and co-conspirator, and person 39, the chairwoman of a political organization whose objective was to elect a broad set of Republicans at a federal and state level, including the defendant and other allied candidates. So it's clearly a partisan exercise where he is operating as a candidate, not as a president in any official role in the presidency that is in the Constitution. In fact, the Constitution in Article 2 divests election powers out of the president's hands and into Congress and states. Person 39's email to the defendant on December 14th was likewise a private communication. Person 39 simply forwarded the defendant an RNC communication summarizing the electoral vote to inform him that the private task the defendant had given her was complete. Was complete. As discussed below, when a White House staffer facilitates unofficial conduct by relaying private political communications, the private action is not converted into an official one simply because an executive branch aide helps carry it out. The defendant's public speeches, tweets, and other statements as candidate were also unofficial, where they were talking about the election. Merely because the president is speaking to the public, even on matters of public concern, does not automatically render the communication official. Instead, what matters is whether the president is speaking or engaging in conduct in an official capacity as office holder instead in an unofficial capacity as office seeker, as determined by content, form, and context. Talking about the speeches in Dalton, Georgia, and the ellipse speech on January 6th, how the RNC paid for the Dalton, Georgia event, and the It was called a victory rally. This nomenclature, the use of the phrase victory rally, is significant. Victory necessitates one political candidate or party defeating another, and rallies are kinds of events that candidates hold to excite their supporters and garner votes. This is talking about the January 4th rally that he went to for David Perdue and Kelly Loeffler. They both lost to Raphael Warnock and Ossoff. I forget his first name, Senator Ossoff. Moreover, the defendant's campaign sent numerous fundraising emails before, during, and after the speech confirming the event's private nature. This rally is going to be, so then it talks about the tweets that are sent out. This rally is going to be epic. It will show the nation the real Americans like you are fired up and ready to fight to keep our Republican Senate majority. So here's talking about in the Dalton, Georgia rally about keeping Senate majority. It's talking about how keeping those two Georgia seats would have kept the Senate majority, which they didn't keep. The energy of the American people was unmatched, and I know we're going to win big tomorrow. It's went to talking about his reelection and also the election, not his reelection, his reelection and election of those two Republican candidates. Then going to the Ellipse speech on January 6th. The content and context of the Ellipse rally, including the people involved in organizing the rally, demonstrate that it too consisted of non-official conduct. The Ellipse rally, named the Save America rally or the March for Trump, was planned and executed by private political supporters, including Women for America First, a 501c4 organization that advocated for defendants' re-election in advance of Election Day 2020 and throughout the post-election period. So the Ellipse rally was originally planned for the Freedom Plaza, but then it was changed to the Ellipse and then featuring defendant as a guest. The rally was categorized by the United States Secret Service as being a campaign event, and it was funded entirely by the heiress of Publix grocery stores. The private funding, while not dispositive, is a strong indicator that the event was unofficial. It describes the event as the defendant's remarks at the Save America rally, using a word rally that reflected an unofficial campaign event. Defendant's White House employees understood the rally and the defendant's speech at it to be private, unofficial exercise and acted accordingly. The morning of the rally, an email from White House photographer, person 67, on which person 45 was copied, provided a reminder today is a political event. Likewise, defendant's White House speechwriting staff understood the speech was a political unofficial one and used their personal devices and personal email accounts to do most of the drafting and fact-checking of the defendant's Ellipse speech, though some last revisions of the speech on the morning of January 6th occurred on White House email. All officials in the White House counsel's office who customarily review the defendant's official remarks pointedly did not review the Ellipse speech because it was an unofficial campaign speech. Similarly, the White House website in the moments after the defendant's speech at the rally made no mention of it. By contrast, the speech was advertised heavily by the defendant's campaign Twitter account, which also repeatedly posted clips of the event in progress and afterward. Tellingly, the significant similarities with the defendant's Dalton campaign speech confirmed the ellipse speech delivered just 2 days later was private and partisan electioneering. The defendant covered many of the same topics and told many of the same lies about fraud in only his election, in some cases, using the exact same words. There's a lot of example from the various states, from Georgia to Arizona, from Arizona to Georgia to Michigan to Nevada to Pennsylvania to Wisconsin, where these claims were made of people voting or people who were dead who were voting, or illegal harvesting of votes. The defendant's language throughout the speech was that of a candidate focused on his reelection. He claimed that he would not concede that he received more votes than he had 4 years ago, 4 years earlier, that the election was over by 10 p.m. on election night, and that he wanted to go back 8 weeks to fix the election results. Significantly, he made many of these statements at the beginning of the speech, framing the themes of the rest of the speech. His tweets. In the initial matter, the defendant sent or directed the sending of all tweets and retweets from Real Donald Trump, the personal Twitter account of the defendant that started long before the presidency. And he used it throughout the presidency until his account was suspended, and then now he uses it again. The Supreme Court's decision in Linked v. Freed confirms that a public official's personal social media account can be used both personal and public business, and consistent with Trump, that a fact-specific inquiry is required to discern into which category a post falls. In conducting the necessary tweet-by-tweet analysis, context and content matters. Simply because a tweet relates to a matter of public concern does not automatically transform it into an official communication. So I'm going to read. For example, he announced over Twitter that Rudy Giuliani and others were taking over his campaign legal team, and he repeatedly used the platform to espouse false claims of election fraud and promote political rallies on his behalf. Person 45, the defendant's deputy chief of staff, Dan Scavino, was the only person other than defendant with control over the Real Donald Trump Twitter account. Acknowledged that he sometimes consulted with campaign personnel about material he was going to post on the account, that he worked as a volunteer for the defendant's campaign at the same time that he served as deputy chief of staff, and that he did not differentiate between his official and campaign duties and when he would send tweets on the account for campaign purposes as campaign volunteer. The review of defendant's official POTUS 45 account presents a relevant contrast. The defendant used this institutional account primarily to retweet other accounts like the Real Donald Trump account, as well as the White House account. There were 74 tweets from POTUS 45 account during the charged conspiracies. None of them include the defendant's election-related claims or his election challenges. So here you're sort of differentiating the two, where even in tweeting, you have to look at every single tweet. Tweets as candidate casting doubt on election integrity are doing it in the capacity of a candidate. Just as his public statements on the election were unofficial, so too were analogous tweets that the defendant posted in his capacity as candidate. And he focused only on fraud claims that would affect his own election and fixated on his own margin of victory, not caring about anybody else's. On multiple occasions, the defendant used a tweet or retweeted an agent's tweet in order to attack individuals who had spoken out publicly to defend the integrity of the 2020 presidential election and assure the public that they had not been outcome determinative fraud. Talked about the Philadelphia city commissioner and how targeting him caused him to get death threats. Looking at the people that he targeted in Georgia, targeting Pennsylvania legislators. Tweets attacked 4 Pennsylvania legislators who, like Person 18, had issued a public statement that they could not overturn the valid election results. Both of the defendants' retweets on December 6th were unofficial. So whenever Donald Trump worked in the capacity of a campaigner and an office seeker, and here we see that he does that many times. He goes after a justice of the Wisconsin Supreme Court after the court said that there was no outcome determinative fraud. Then the Secretary of Georgia, the Secretary of State of Georgia, and the Secretary of State and Governor of Arizona. So throughout the post-election period, the defendant used his status and power as the head of a political party to bring political pressure to bear upon fellow Republicans, including Arizona governor, Georgia governor, and Georgia Secretary of State. Defendant's multiple tweets on this topic included his initial message that there would be a big protest in DC on January 6th. Be there, will be wild. This was sent through his real Donald Trump account, and it's talking about his campaign. It's not anything to do with his official duties. And Jack Smith is exhaustive with every single tweet that is implicated, that is being brought up in this case. So the context and content of these tweets established that they were unofficial. Through the tweets, the defendant was using the political pressure of his supporters and social media followers to convince Pence to take an action to benefit the defendant as a candidate and help him overturn the results of the election. The defendant played no official role in the congressional certification proceeding and was not using his tweets about Pence's role to advance any executive branch or governmental interest. So carrying on, the defendant's tweet on January 6th, that was sent out at 2:24 p.m. The defendant's tweet aimed at Vice President Pence was unofficial. The defendant personally posted the tweet on the afternoon of January 6th at a point when he already understood that the Capitol had been breached, writing, "Mike Pence did not have the courage to do what should have been done to protect our country and our Constitution, giving the states a chance to certify a corrected set of facts, not a fraudulent or inaccurate ones, which they were asked to previously certify. USA demands the truth." So that was after, and soon after that, Pence had to evacuate. At 11:15 a.m., defendant called Pence and tried a last-ditch effort to convince him to fraudulently reject or return Biden's legitimate electors. Pence was resolute and unmoved, and the defendant was furious. Immediately after the call, the defendant directed the original language targeting Pence to be reinserted in his prepared remarks in the Ellipse rally. He purposely singled out Pence by claiming that Pence had the power to overturn the election, and though the defendant stood at the podium with full knowledge that Pence would not do so, gave the crowd false hope that Pence might exercise that power. And then there's a sort of a distinction between his tweets that came afterwards, where he was talking about a public concern, was telling them to go home, And those tweets are markedly difficult, are markedly different from the ones where he is directing and attacking and targeting people, or telling them to go to the Capitol, or not saying anything for more than an hour, and then after an hour attacking Mike Pence, and then not saying anything for another hour, more than an hour, and then finally sending out tweets saying that, do it peacefully. The police officers are on our side, and then later on at 4:17, calling his rioters special people and how he loves them very much, and then conveying an even more cantankerous uh, tweet at 6:01, saying that his win had been unceremoniously stripped. So those are all political statements as a campaigner. The content of the 2:24 p.m. tweet was not a message sent to address a matter of public concern or to ease unrest like the ones later on. It was a message of an angry candidate upon the realization that he would lose power. Each of the defendants' cited public statements was made in his capacity as candidate. His election night remarks were made to a room of his supporters and were about his status as a candidate in a pending election. Redaction of any statements ultimately found to be immune, while admitting the significant remaining unofficial content, would resolve any constitutional questions about these sets of tweets. It's if you're found to be immune certain of those tweets, then they can be taken out, redacted, and the other tweets should still remain, because because immunity is conduct specific. It's not doesn't go with the office. Just because you're sitting in as president doesn't mean that everything that you do and everything that is said is therefore immune. That's not how the immunity works. That's not how speech or debate clause immunity works. That's not how presidential immunity works, now that the Supreme Court has devised an area where there is immunity for former presidents and presidents. So defendant's interactions in his capacity as candidate with White House staff. White House staffers witnessed or engaged in private, unofficial communications with the defendant. Federal law confirms that the defendant's campaign-related conversations with these White House staffers were unofficial. The Hatch Act permits certain White House staffers to engage in political activity while on duty, but prohibits them from using their official authority or influence for the purpose of interfering with or affecting the result of an election. And when the president, acting as a candidate, engaged in campaign-related activities with these officials or in their presence, he too was not engaging in official presidential conduct. The transmission of a private campaign communication by or to the defendant through a White House employee serving as an intermediary did not render the communication official and thereby shield it from use in a criminal trial against the defendant. In sum, just as the president can at times act in an unofficial capacity, including as a candidate or a party leader, candidate for office or party leader, so too can the executive branch staff around him. Simply because a staffer holds a title in the executive branch and interacts with the president does not mean that interaction is necessarily official. When the individuals listed below interacted with the defendant in the circumstances described in Section 1, those conversations were unofficial. As part of its immunity analysis, the court should consider multiple different interactions involving Person 9, none of which bear on his official White House responsibilities. The content of each Person 9 communications with the defendant enumerated above involve the defendant's campaign including the status and viability of the defendant's fraud claims. The quality of the advice, the quality of the advice the defendant was receiving from his campaign advisors, his litigation and electoral prospects, and the legality and practicality of John Eastman's proposal that Pence reject Biden's legitimate electors at the certification proceeding. None of those communications pertain to general election policy issues or considerations. Justice Department criminal investigations, executive branch functions, or any other presidential responsibilities. Person 9 was not acting in an official capacity during the conversations enumerated above, but as a conduit for information from the campaign. And there's a lot of going on conversations. Throughout these conversations, even if person 9 could be understood to have been acting in an official capacity, which he was not, rather than a campaign one, the defendant himself acting in his private capacity was himself acting in his private capacity as a candidate. The defendant was asking for person 9 view on various strategic decisions he was making regarding his campaign and his private attorneys, and he was getting reports from person 9 on information related to actual and potential election challenges important to his candidacy and private campaign. All of this context establishes both that person 9 wore two hats, one official, one private, and that defendant interacted with person 9 in these conversations as a candidate rather than president. The interactions between the defendant and person 9 that the government intends to introduce at trial were thus all private. Then there's person 45, who was the deputy chief of staff, Dan Scavino. He also volunteered his time for campaign work. The Twitter account, he sent tweets only on defendants' express directions, whether they be private or official. Then there's the assistant to the president and volunteer to the campaign, and she would testify in two specific conversations of a handful of conversations in which defendant in advance of the election said he would simply declare victory, and an unprompted statement in which defendant remarked in a private moment that Sidney Powell's claims were crazy. In that context, the defendant told person 7 and others words to the effect of, "We'll just declare victory." Regarding the defendant's statements about Sidney Powell, person 7 will testify about November 20th phone call in which the defendant mocked and laughed at Sidney Powell and called her allegations that he adopted and amplified crazy. So we're talking about the election, talking about people in election, then saying that it doesn't matter if you won or lost the election, just you still have to fight like hell. Happened to overhear his comment, but was not participating in the conversation, who was person 15, assistant to the president of and director of Oval Office operations. This statement was plainly private. It was exclusively about election and the defendant's determination as a candidate to remain in power and whether or not he lost. So I am going over each of them because this exhausting information that is provided, matching up facts with the law and the analysis, shows that Donald Trump's tweets and that are implicated in the superseding indictment and his communications with people all around him who were not privy to the actual internal workings of the full conspiracy, like the 6 co-conspirators are. You get to see this picture evolving, that Donald Trump was using every power that he could, every way that he could, but he was operating himself as a candidate because he wasn't doing anything over which the executive has any power. And that is by way of the Constitution. And that's not something the Supreme Court can change either. None of these actions by person 42, in which she was merely facilitating communications between the defendant and his private attorneys or private political allies, constitute defendant's official conduct. So, the Donald's officials' conduct and their words and whatever else, they have to fall with Donald Trump. If Donald Trump wasn't acting in his official capacity, the person who was conveying and being an intermediary about the information was also not working in the capacity of that is constitutionally under the executive branch. They were working as campaign support for Donald Trump. When they are speaking to the president in his capacity as a candidate or in their campaign related capacity, does not impede decision making on matters entrusted to the executive branch. The Supreme Court required that its rebuttal analysis focus on the executive branch authority and functions, not merely on anything that the president might say or do while in the White House. Here, the executive branch has no authority or function in the certification of the next president. Accordingly, the use of evidence of White House staffers' campaign capacity discussions with the president about how to challenge state election results, challenges brought in his capacity as candidate, does not risk impairing the constitutional role of the executive branch. So then there's talk about how Attorney General Bill Barr independently set out a statement saying that there's no election fraud, and Chris Krebs, who was overseeing the elections, was among 59 election experts who came up with an independent letter saying that there was no election fraud. And obviously, the defendant was so upset he asked for Bill Barr's resignation after hearing about it, and obviously, was later talked down. The government does not intend to introduce any evidence about the defendant's removal of Person 50. Rather, as with Person 52's public statement, Person 50's public tweets were not official actions by the defendant and thus are not protected by presidential immunity. So here the argument is that those people, they have been working under the president, but they did not send out those documents, those press releases in their official capacity as doing some sort of an official function that is delegated to them. They were not directed by defendant to make those statements. They did so by themselves. And does that qualify as Donald Trump working in his official capacity? How could it? Donald Trump did not have knowledge of it. In turn, the government will introduce the authenticated coverage showing that Fox News was playing in real time while defendants sat in the room with the television on. This evidence is particularly relevant to the defendant's knowledge at the time he issued the tweet at 2:24 p.m., which, as directed above, was unofficial, as described above, was unofficial. None of this evidence involves testimony about an act by the defendant at all, and it shows what social media and news the defendant privately reviewed in service of issuing a private tweet. The defendant's review of social media and television news under these particular circumstances was no different than any other citizen or candidate, and therefore was unofficial. The defendant's endorsement of the violent actions of his supporters on January 6th and his sentiment that they were justified in threatening Pence, all made while defendant was a private citizen at the end of his term in office, are probative of the intent during the charged conspiracies. The government intends to offer them as evidence of the defendant's intent on January 6th, not as evidence of his official acts. So here, Jack Smith is sort of saying that we're going to provide some of this information that you might consider official, but not for evidence of his official act, but rather Donald Trump's intent. And that would happen in the criminal case, not in the evidentiary hearing about immunity. Nothing in Trump v. United States dictates Such an outcome would effectively bar any executive employee from providing evidence against a president who committed crimes in his private capacity. Put concretely, allowing these independent acts of executive branch officials to be used in the prosecution would not chill any presidential conduct, and thus any presumption of immunity is overcome. So with that, Jack Smith asks the government, Jack Smith and the government asks the court to issue a single order that the government has rebutted the presumption of immunity attached to the defendant's official communications with the vice president, and that the remaining conduct described in Section 1 was not official, and in the alternative, that the government has rebutted any presumptive immunity for any of the remaining conduct that the court finds to be official. The government requests alternative rulings regarding rebuttal for all the conduct the court finds to be unofficial to buttress the court's record, ensure thorough and efficient appellate review, and minimize the risk of successive rounds of interlocutory appeal. So that is the ask. Furthermore, based on the determination that all the conduct described in Section 1 is not immune from prosecution, and because Section 1 encompasses all the allegations in the superseding indictment, the court should further specify that the defendant is subject to trial on the superseding indictment, and that the government is not prohibited at trial from using evidence of the conduct described in Section 1, subject at a later date to non-immunity based objections and this court's admissibility rulings under the federal rules of evidence. The end. So this is me saying that we have done an extensive summary of this of the opening brief, and I hope that it gives you an idea of where things stand legally and where things stand on a governmental standpoint. Now we're going to wait for Donald Trump's reply. Then we're going to get the government's response to the reply. Then there's going to be a time allocated by Judge Chutkan to have oral arguments on this, and then she will make a ruling. And it's very likely that Donald Trump will want to appeal that ruling. But I don't think that the Supreme Court will favor Donald Trump after this ruling, because I see at least Judge Chutkan going with at least 90 to 95% of what Jack Smith says. There may be some parts where Judge Chutkan may exclude some evidence, some of the information brought up, but that is up to Judge Chutkan. And the lower court has broad discretion in how it deals its pretrial matters. And we'll see in Judge Chutkan's ruling how she herself interprets the Trump v. United States ruling, because we'll also see Donald Trump's perspective of what he thinks of Trump v. United States when his reply comes in. And if his reply isn't too long and obnoxious, I'll come back and talk about that. So thank you so much for being here. Please like and subscribe, and I'll talk to you soon.